You know, I've been attending these events for 9 years, and they really all start to run together. It's like the classroom that I never had. In high school, you learn things through these conferences, really the truth about things, and things they don't teach in the police academies, do they? Or in law schools, for that matter, so it's really refreshing. I wanted to just focus back, as I introduce our next speaker, on remember the quote from Justice Scalia, the part about that, so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day. The temptation. It reminds me, and if you'll bear with me just a moment, there's a reason for me to do this. There's a scripture that I like. It's from 1 Corinthians 10:13. It says, no temptation, there's that word, no temptation has overtaken you that is not common to man. God is faithful, and he will not let you be tempted beyond your ability, but with the temptation, he will also provide the way of escape, that you may be able to endure it. So as we move towards what you can do, and I know you're all tempted and challenged, and sometimes you feel like the world is crushing in on you, but you're going to gain not just the knowledge, but the spirit that you need to push back. And this next speaker is going to be one of those that's going to equip you in that realm. His name is Michael Anthony Peroutka. He's an attorney from the state of Maryland and is the co-founder of the Institute on the Constitution. And be sure and visit their table back here before you leave today. It's a national education outreach which publishes and conducts courses of instruction on the United States Constitution and the biblical principles on which it is founded. Michael has been an educator and an author on American history and law for over 20 years. In 2004, he was the Constitution Party's candidate for the office of President of the United States, basing his campaign on the theme of honor God, defend the family, and restore the republic. In 2014, he was elected to the county council in Anne Arundel County, Maryland, and served as the chairman of the council in 2018. He's been a member of the CSPOA for many years and has made several previous presentations at CSPOA conferences. Today, his presentation will focus on the question, which law do I follow? And he will be introduced by Jake after a brief introduction. Please, Jake.
I'm the younger, taller, better-looking version of Michael Peroutka. Thank you, Michael. I appreciate that. All right. Should be golden there. Well, thank you very much, and I really do mean this, not being in law enforcement. Thank you for your service, every single one of you here. And every day that you get out of bed and you go defend a country that right now, I think many of us would be ashamed of the way that we think, but yet you still continually do that. So thank you. That shows the dedication. And for all of you that are not law enforcement, I'd like to give them a follow-up hand for your dedication and your service to our country. Now, like most of you, I love the Constitution, I love our country. I didn't always start that way. As a 16-year-old, 15-year-old, you would have saw my rap sheet and you would have known who I was. I grew up in southern Minnesota. I was a very naughty kid. And I wound up getting kicked out of school as a senior in high school and on my way to jail, but I went to a program called Minnesota Teen Challenge. Are any of you familiar with Teen Challenge? Awesome. Hey, by the way, you guys can keep those lights on all the way. I think it's better because the screens really aren't going to be that big of a deal. Just crank all the lights up. But after I went through Teen Challenge, I went through a series of changes in my life. I started going into schools and talking about my testimony, what I went through, and how kids can not make destructive choices. I thought that was a good idea. I didn't grow up a Christian, and so people started throwing at me the separation of church and state and First Amendment and all of this. And I said, what's a First Amendment? Come on, I went to government school. They don't teach us that. And as I studied our founding documents, I found out that the founding fathers would have been right on board with speaking about a creator and unalienable rights and so on. And so that began my journey into studying the Constitution. In 2004, there was a gentleman named Michael Peroutka running for president. And I'm going to get into that in a second, but the Institute on the Constitution spends its time in all 50 states, not 57, 50 states across the Union, teaching the Constitution. We do have a table back there. I would love to share these resources with you. We have graduates all over, everything from federal office down to dog catcher, down to lay people. We speak in hundreds of churches teaching these Constitution courses because I think Christians should know and understand this. And their faith is very much intricately woven into the fabric of these United States because our God gave the blessings of liberty to mankind. Our founder is Michael Peroutka. I serve as the sitting president, and our senior instructor is David Whitney. We have a dean of instructors, Ricky Pepin. She used to work for the FBI, but then she repented, so we let her come aboard. Our vice president is first-generation American, Massey Campos. So that's our organization, and our outreach is a tremendous outreach. These are my puppies, because I just wanted to hear you say, "Aw." You know, this is my family, and I'm very proud of my family. I have my son, Joshua. He's in the back there, 16 years old. We homeschooled our children. One of my sons, the oldest there on the side, is Dominic. He's going to finish his associates when he graduates high school this year. And he was giving an answer in a Bible discussion group and for confirmation, and one of the little kids in the front said, "Pastor, how did Dominic get so smart?" He was like 8 years old, and he sounded like a theologian. And the pastor pointed to me in the back of the room, because we homeschool, and he said, "Do you see that man back there? His wife." I usually put a picture of her up there. She's a stunning, wonderful woman, and like many of you who have your wives at home holding down the fort, could we do it without them? No, founding fathers, nothing. If there was no founding mothers, this wouldn't exist, would it? Who would have educated the kids? See, we get to leave. We get to be the good guy when we come home, right? Mom's got to deal with that on a regular basis. And our curriculum is designed to help mothers. We have a homeschool curriculum as well. So that's enough of the infomercial. In 2004, Michael Peroutka was running for president. And I thought, president of what? President of the United States and the Constitution Party. And his campaign slogan was God, Family, Republic. Now I was fresh onto the scene. I didn't know much about this stuff. I didn't wear a suit and tie yet. And I didn't even vote, even though I was on the good side now. I'd gotten through that high school experience, and now I'm out there trying to reach people, get them to make good choices and be a Jesus guy. And his campaign slogan was God, Family, Republic. And I thought, I didn't know politicians talk about God. Is that even possible? Do they do that? Again, this is coming from my perspective of future generation. I'm old now. I'm 42. But that was my perspective back then. Imagine this generation's perspective now. There's no God in politics. There's no God in D.C. What does that got to do with anything? When you start speaking that way, there's this window shade of disbelief over their faces, like, what are you talking about, bro? And that's a tragedy. We want to rectify that. But as Michael came to town, I said, can we meet? And he came and he met, and he gave he very kindly gave a speech to our group, our ministry. And he said, Jake, you got to understand the founding documents. You got to understand that your faith is tied in with that. You got to understand what the blessings of liberty truly are. And that set me on a course. And fast forward to here, over 2 decades later, with the Institute on the Constitution, having traveled throughout the country and met many brave men and women such as yourself, but also thousands of lay people that are hungry for this. Just talked to one of our chapter leaders out in Ohio. She's overseen the graduation of 6,000 people from our Constitution course, many of whom now serve in office. And she said, Jake, it's catching fire again. We just packed out a venue, and we're having a hard time finding venues because of COVID and so on. But the demand is there, and the support is there for each one of you. So I want to encourage you with that. And by way of that, through my testimony and the ability of what I've been able to experience, it's been as a result of my friend and my mentor, Mr. Michael Anthony Peroutka. Can you please help me welcome him?
Which law do I follow? A long habit of not thinking a thing to be wrong gives it a superficial appearance of being right. Let me quote Thomas Paine again. A long habit of not thinking something to be wrong gives it a superficial appearance of being right. Notice that Thomas Paine didn't say it makes it right, just gives it a superficial appearance of being right. Matter of fact, this is the very first sentence in the book, Common Sense. This is his very first sentence. I'm going to come back to Thomas Paine in just a minute here, but I want to thank Sheriff Mack for his faithfulness, his courage, and his consistency in this movement. I also want to mention Dawn Mack. Thank you, Ms. Dawn. Thank you, Tanya. Thank you, Sam Bushman. Thank you, Anna Bushman. Thank you, Sheriff Henderson. And thank you for this spectacular the place, the Woodlands. I never knew this was here. This is an unbelievably spectacular place in a spectacular state of Texas. So I'm very grateful for the opportunity to be here. A long habit of not thinking a thing to be wrong gives it a superficial appearance of being right. Doesn't make it right. Just gives it a superficial appearance. We have some long habits of doing things wrong. We're going to talk about them briefly today. And I recognize, folks, I'm talking right before lunch. So just in case I don't get to it, here's the conclusion. If they cut me off, this is the end of my talk. All right? I'm giving you the end of my talk at the beginning, all right? When a peace officer refuses to enforce an unconstitutional enactment or order, the peace officer is not breaking the law. He's upholding the law. He's actually validating the law. He's actually vindicating the law. All right, this is the end of my talk. I'm going to come back to this. So let's start here. There's an American view of law and government. Matter of fact, we at the Institute on the Constitution, we capitalize the American view because it's a particular view. We consider it to be a proper noun. There's a particular view of law that's American in nature. It's contained very concisely and precisely in our Declaration of Independence. I wonder if you would repeat this after me. There is a God. Our rights come from Him. The purpose of civil government is to protect God-given rights. All right, let's do it like we mean it. There is a God. Our rights come from Him. The purpose of civil government is to protect and defend God-given rights. It's not to make sure your seatbelt is buckled. No, you don't have to repeat that part. Thank you, but I appreciate your help. It's not to make sure your seatbelt is buckled. It's not to make sure you're wearing your helmet. It's not to make sure you're eating your veggies. And it's not to protect your health. The purpose of civil government is to protect your liberty so you can protect your health. Okay? Now, this is the American view of law and government. And by the way, it's the law. The U.S. Code says the Declaration of Independence is the organic law of these United States. So that philosophy of government that I just expressed is the law. Think about that for a second. Anything that's contrary to that purports to be law, can't be law because it violates the organic law. And part of that organic law, let's say it again, think through it again. There is a God. That's the law in America. Our rights come from Him. And the purpose of civil government is to protect and secure those God-given rights. So what's the problem now? What's a peace officer trying to do? Am I a little loud here? I feel like I'm really loud. I don't want to be too loud. I'm going to leave for lunch early if I'm too loud. As peace officers, what we're trying to do is discern our duty. We're trying to keep the peace. We're trying to maintain order. We want to protect and defend the citizenry. We want to do the right thing. We want to follow the law in, as it's been expressed by speakers already, a very, very lawless time. And frequently you hear this question, Sheriff Mack referred to this, which law do I follow? And I'm going to submit to you that that's not the right question. And the answer that you sometimes hear from law enforcement folks is, I don't get to choose which laws I follow. The sheriff of my county in Maryland said this, I don't get to choose which laws I follow. But that's not, actually, interestingly, that's not the right answer. And it is the right answer. I trust I made myself obscure. I hope I can make myself clear, okay? It's not the right answer, but it is the right answer depending on what you mean by the law, right? Because your duty is to follow the law. There really is no conflict. There is really no conflict. Sheriff Mack said I was going to get all over him for calling what was it? Martin Luther King actually said it in what I would consider to be wrong. He talked about unjust laws. My point is that an unjust law is not a law. It can't be. For a little brief 60 seconds on Blackstone, Blackstone said that any law, by the way, he wrote commentaries on the laws of England, very influential on our founders. George Washington would have read Blackstone. And he was about a half a generation before our founders, in a sense. And he said that all law, what he called municipal law, that's man-made law, has to be consistent with and in harmony with the divine law, or it's not law. So there's an eternal standard for law. Just think of it as the Ten Commandments. If laws violate the Ten Commandments, they're not law. Excuse me, I said it myself. If enactments or orders or edicts violate that, then they're not law. Blackstone would have said, and our founders would have understood them not to be law, and I'll get to that in just a second. So following the law is what the oath is all about. As a matter of fact, Sheriff Mack, and I used this picture because I thought he had a nice Elvis thing going here, don't you think? Sheriff Mack said, the choosing is done, the choosing about which law is done when you took your oath of office. Because you took your oath of office and your allegiance was to the law, not unconstitutional enactments, orders, edicts, mandates, whatever you want to call them, right? But how do I know? Whether an enactment from a legislature or an order, whether you call it a mandate or a proclamation or an edict or whatever, from an executive, how do you know if it's law? Well, you have to apply the standards. So what is law? Where does it come from? And is there a difference between law and an unconstitutional act or an unconstitutional mandate, order, edict, etc.? Of course, and the answer is yes, there is. The Supreme Court, and by the way, I'm not going to quote the Supreme Court here because they're always right. They just happen to be right in this time, that's why I'm quoting them. But way back in 1886, the Supreme Court in Norton versus Shelby County said, an unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protection, it creates no office. It is in legal contemplation and as inoperative as though it had never been passed. Right? So unconstitutional acts not only are, they're not, you don't have to wait for a court or a judge or a series of judges to declare something to be unconstitutional. By waiting, justice, you've heard it many times said, justice delayed is justice denied, right? You don't have to wait. And yet, in St. Mary's County, Maryland, I was on the same dais with a sheriff who said, well, we'll just wait and let the judges decide. But you do people harm when you do that. You violate people's rights when you do that. The Supreme Court also said very directly here that all laws which are repugnant to the Constitution are null and void. Ab initio, from the beginning, from their inception, not just when a judge says so. Now, Sheriff Mack referred to this as well. From the Declaration of Independence, you know what they called acts of Parliament for which the colonists said that there was no justification, there was no authority? They were, of course, complaining about the Stamp Act, the Tea Act, what they called the Townsend Acts, what they called the Intolerable Acts. They were saying, Parliament, you have no authority. The charters we have from the king, what you're doing violates those charters. You have no authority over us. But they were doing it anyway. So what they called that in the Declaration? They called those pretended legislation. They didn't call them law. They didn't say they wouldn't have said there's a face mask law. They would have said there's a piece of pretended legislation. Actually, there's not even that. There's a pretended mandate or order or edict, right? So they said in the Declaration, he, being King George III, has combined with others, being Parliament, to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to the acts of pretended legislation. Please remember that term, pretended legislation. It's not only historic, isn't it very accurate? It's what we're really facing here. These things, we should not be giving them the mantle of law. And you know what? If you were accused of violating an act of pretended legislation, They called that a pretended offense. They said, for transporting us beyond the seas to be tried for pretended offenses. This, again, is the Declaration of Independence. They didn't call those things laws, and we shouldn't either. Now, who's empowered to decide? You are. Everybody that takes an oath of office is, within their jurisdiction, is empowered to decide and compelled to decide whether something is law or an act of pretended legislation. And when does this decision take place? Well, it takes place all the time. You do this all the time. So it logically follows that it would be unlawful for a sheriff to enforce acts of pretended legislation or to be in any way complicit in their enforcement. I'm telling you stuff you already know here. It also logically follows that it would be unlawful to enforce mandates or edicts or orders from a governor, a mayor, a health department official, or any executive branch employee which violate the U.S. Constitution or the Constitution of your state. You can't be complicit in that. Also, logically and legally, local elected officials who are sworn to uphold the Constitution are duty-bound to protect the people under their care from those that would wrongly enforce that which is clearly not the law. That's the whole concept that you read about, that Sheriff Mack told you in Prince and Mack versus the United States. This is interposition. You're not only not supposed to enforce these things, you're supposed to act against their enforcement. Pretended legislation, ladies and gentlemen, is not law. It's a violation of law. Pretended legislation is a violation of law. Therefore, the refusal to enforce pretended legislation, whether it comes from the judicial branch or the executive branch, as I said earlier, is a validation of the law. It's a vindication of the law. Now, I took the liberty of writing a letter for you. At our last conference, I wrote a letter, I proposed and distributed a letter that I had written that I suggested that citizens could give to members of law enforcement that they knew or that they ran into. And, you know, almost everybody has a brother or cousin or uncle or somebody who's involved in peacekeeping somehow. And my idea was that this letter could be shared. Well, I took the liberty of changing it around a little bit because I think that it would be much more effective if it came from you. If you shared these thoughts with other sheriffs. And it's actually, a copy of it is available back on the table in this little green pamphlet here. But let me just go through it with you very quickly. Dear fellow sheriff and fellow American, and please, I would like your thoughts about this, ladies and gentlemen, how this might be able to be used and how CSPOA might be able to help with the distribution of it. Some say that this current COVID-19 crisis makes it necessary to suspend the exercise of God-given constitutionally protected rights, including the freedom to practice religion, freedom of assembly and association, as well as the freedom to move about without molestation. But this is precisely what is forbidden by the Constitution of the United States. Moreover, our state constitution provides that all lawmaking power is vested in our state legislature. This is what we call the separation of powers, right? And further provides that the powers and authority of one branch of government shall not be discharged by an official from a different branch. Now, this is not part of the letter, but I put a little aside in here because I'm in Texas. I just looked up Article 2, Section 1 yesterday, and it says the powers of government of the state of Texas shall be divided into 3 distinct departments, and no person or collection of persons being one of those departments shall exercise any power attached to either or the other. In other words, lawmaking power is in the legislature, and the governor can't make it. He can't do that. And courts can't do it either. The lawmaking power is vested, meaning it can't be divested. So the legislature can't pass an emergency act and say we give the governor the ability to make law. No, you can't do that. That's not law. That's a violation of law. That's pretended legislation. So anyway, back to the letter. So, lawmaking power is vested in the legislature, meaning the governor has no constitutional authority to make law. Therefore, the edicts of our governor, or one of his health department subordinates, whether they are characterized as mandates, orders, proclamations, or directives, are not law and cannot be lawfully enforced. In point of fact, no governor in any state has the authority to suspend the Constitution. Interestingly, again, another aside, in my state, the governor suspended the Constitution. Now, the office of governor is a creature of the Constitution. So if the governor suspends the Constitution, What else does he suspend? It's an act of lawlessness and a violation of his oath of office. Respectfully, when you and I took our oath of office as a sheriff, police, or other law enforcement official, we swore obedience and fidelity to the United States Constitution and the Constitution of our state. We did not swear allegiance to a mayor or a governor or a health official. Right now, it is crucial that we remember that solemn promise and live up to its terms. Because right now, as our country and our communities are in peril, it is especially imperative that we rededicate ourselves to this noble calling and this duty. And of course now, here's where the rubber meets the road, and I'm underlining it here. Our fidelity to our oath and to the rule of law require that we abstain from enforcing any edict or order from a governor or any executive which lacks constitutional authority. Moreover, our duty requires that we resist such edicts, interpose, and orders, and that we act in such a manner as to shelter and protect the citizenry, like the Rosa Parks example, from all acts of lawlessness, even and especially when they originate from civil authorities. So, again, taking liberties to write a letter for you, but I'm hoping that this might be this articulation, or any that you would choose to, please feel free to change it, alter it, make it yours. This might be an effective way to try to get the message to other sheriffs. Because the sheriff is empowered and expected to discern and decide whether enactments or edicts of law are law or pretended legislation. And he's expected to know what the Constitution says and what it means. He can't punt this to a judge. He's not in any way compelled to pass the decision to a court or to an executive branch operative. And let me assure you right now that I mean no disrespect to anyone. But please listen to what I'm going to say here. The sheriff is not dissuaded from his duty by some functionary whose allegiance is compromised. Because the trouble with your county attorney is that he went to law school, where he didn't learn the theory of law as George Washington learned it, and as Thomas Jefferson learned it, and as James Madison learned it. He learned it from a model called the case law method. Whole nother lecture. Don't have time to go into that right now. But it's really a way of looking at law which Chief Justice Roy Moore, my friend in Alabama, calls unlaw. In law school, you're taught unlaw. It's a big problem. And I don't mean to insult any county attorneys, and I don't mean to insult any attorneys. But in law school, you would have been trained up in a manner of understanding unlaw in such a way that you would think pretended legislation is lawful. This is Article 8 of my Maryland State Declaration of Rights, which is part of our Constitution. It's the first part of our Constitution. And it says this, that the legislative, executive, and judicial powers of government ought to be forever separate and distinct from each other. This is like the Texas thing I quoted a minute ago. And no person exercising the functions of one of said departments shall assume other or discharge the duties of any other. This is Article 44 from the same Declaration of Rights. This could not be more on point, ladies and gentlemen. Please, and your Declaration of Rights or your Constitution in your state might have something similar. I've actually never seen something so on point as it is in my state, in Maryland. Not that it has affected the duties of our legislature or our governor, but it says this. This is the law. This is the Constitution. That the provisions of the Constitution of the United States and of this state, being Maryland, apply as well in time of war as in time of peace. And any departure therefrom or violation thereof under the plea of necessity or any other plea is subversive of good government and tends to anarchy and despotism. There's no COVID-19 exception to the Maryland State Constitution. There's no COVID-19 exception to the Bill of Rights. There's no emergency exception to any of this. As a matter of fact, emergencies is when you should follow the law, when you need the Constitution, not when you should depart from it. Which is why Institute on the Constitution is working on a state constitution project. We are now developing constitutional courses of instruction for every state. We're working on it with people in each state. We'd love to partner up with any of you if you'd like to help with that. That's something we can learn about back at the table. But we hope to, in the next few months, complete this project. It's a big project But if you'll find that the Constitution of your state probably is even more comprehensive in many cases than the U.S. Bill of Rights. You know, I went to law school about years ago in Maryland, and in Maryland there are two law schools, University of Baltimore and the University of Maryland. And everybody that graduates from there that becomes an attorney, who becomes a judge, who becomes a legislator, whatever, they all take an oath to the Maryland State Constitution. You know, neither of those law schools have a course of study in the Maryland Constitution. I would venture to say that probably in your state there's no course of study in your state constitution in your law schools. That should be a red flag to you. All right, I just want to finish here by talking about a case that happened in Maryland recently. A Maryland man that I know, was arrested and accused of refusing to wear a mask at the polling place. This was on November 3rd in one of our counties. And the county sheriff's people came and arrested him. The sheriff's deputies arrested him. And as I think Sheriff Everson talked about, that the use of trespass, I'm not sure if it's you, sir, but somebody said the use of trespass rather is a subterfuge for not wearing a face mask, and it's not the correct thing to do. Anyway, a citizen of that county wrote to the sheriff and said what you did was unconstitutional in arresting Mr. Dan Swain. He was the gentleman that was arrested at the polling place for refusing to wear a mask. And the sheriff wrote back and said this. I'm not going to say the sheriff's name, but he said to the citizen, as to the governor's ability to issue executive orders using the emergency powers granted to him by the state legislature, having the authority of law, which is an interesting phrase, having the authority of law. Where did the authority of law come from? By the way, it should be a red flag to you when somebody says, this has the force of law. This has the authority of law. Anytime you hear somebody say, this and this has the force of law, you know it's not law. Because if it was law, they'd say it's law. What they're saying is thus and such has the force of law, has the authority of law. That should be a red flag that whatever they're talking about ain't law. Anyway, that's what he says here, and he refers you to the Annotated Code of Maryland, the public safety article, where the legislature says that the governor can have these powers. But they can't give the power to make law to the governor. They can't do that. It violates the Constitution. And he says this, which I think is interesting. This is, again, the sheriff. He says, this law, he calls it a law, he says, has not been found to be unconstitutional. Well, what does he mean by that? Has not been found. Well, who's supposed to find it unconstitutional? Who's supposed to make that decision? This is the sheriff writing to a citizen. I already gave you this warning. Somebody says the force of law. When they use this term, they're tacitly admitting that whatever they're talking about isn't law. The sheriff goes on. He says, to be clear, I'm no fan of the governor's order for face coverings. In fact, I'm not a fan of many laws approved by our legislature, but being opposed to them and saying they're unconstitutional is quite a leap. Well, no, it's not. It's not a leap, depending on why you're opposed to them. His personal thoughts about the law, that's not important here. What's important is whether or not it violates the Constitution, whether or not it's authorized by the Constitution. So I just wanted to point that out. These are arguments that you hear, and that was the argument that he gave, which I think is very, very, very faulty. Because he claims, interestingly, that the constitutionality of the decision to arrest someone for wearing a mask is outside his jurisdiction, yet he made the decision about its constitutionality by using the police power to violate the rights of Mr. Swain. So while he's saying it's not my call, he made the call. So there's no choice to be made about which law to follow. There's only one law, and your duty is to enforce that law. But to do that, you must know what law is and what law isn't, and don't let any graduate of law school deceive you and dissuade you from your duty of interposing on behalf of your constituents. Here's the end, which was the beginning. Here we go, right? When a peace officer refuses to enforce an unconstitutional enactment or order, the peace officer is not breaking the law. He's upholding the law. He's validating the law. He's vindicating the law, which is his duty. God bless you. Thank you for your kind attention. Thank you. Thank you very much.